Reporters Without Border in the top 10 of countries with a very free press. And I endorse that. That's something we support. On to the substantive matter at hand, and Lincoln did say we're going to focus entirely on the issue of the Supreme Court's ruling on the matter of Arthur Williams versus Andrew Holness. And this has implications for the composition of the opposition in the Senate. The ruling has raised questions about adherence to constitutional provisions, and it has also raised much public interest. And today the Attorney General has studied the ruling, and today he is here to give us his opinion, the opinion of his office, and to answer your questions. And I now turn to our Attorney General, Mr. Patrick Atkinson.
Good afternoon. Consequent on the decision of the court in Arthur Williams versus Andrew Holness, the following issues have been raised. 1. Whether the effect of the ruling is such that Mr. Arthur Williams and Dr. Christopher Tufton remain senators. 2. What is the status of Mr. Roel Reed and Dr. Nigel Clark? And 3. Since Mr. Reed and Dr. Clark may not have been validly appointed as members of the Senate, what is the impact, if any, on their participation in the Senate and on other committees of that House? The court in Williams and Holness made the following declarations. 1. That the request for the procurement of pre-signed and undated letters of resignation and letters of authorization by the leader of the opposition from persons to be appointed or appointed as senators upon his nomination is inconsistent with the Constitution. It is contrary to public policy. It is unlawful and is accordingly null and void. And 2, the court ruled that the pre-signed and undated letters of resignation and letters of authorization, as well as the manner of their use to effect the resignation of senators, the claimant in particular, from the Senate of Jamaica, are inconsistent with the Constitution of Jamaica, contrary to public policy, and accordingly null and void. I'll focus firstly on the ruling of the court that the pre-signed and undated letters and their use to effect the resignation of senators are null and void. Black's Law Dictionary, 7th edition, defines null to mean having no legal effect, of no effect whatsoever, without binding force, and void to mean of no legal effect and null. Essentially, the court found that the claimant had not resigned his seat. A senator or member of parliament holds his seat until the next dissolution of parliament after he has been appointed, unless he has resigned or certain other events occur, such as the senator or member ceases to be a Commonwealth citizen or commits certain specified breaches, none of which apply to these circumstances. The purported resignation of Mr. Williams, and by extension that of Dr. Tufton, has been adjudicated to be unconstitutional, unlawful, against the public interest, and accordingly null and void. I am of the opinion that Mr. Williams and Dr. Tufton are still members of the Senate and are entitled to take their seats. Regarding the status of Mr. Reed and Dr. Clark, the court did not specifically address the purported appointments of either Mr. Roel Reed or Dr. Nigel Clark to the Senate, which were made on the unfounded basis that Senators Arthur Williams and Christopher Tufton had resigned and left 2 seats vacant. The Constitution of Jamaica allows for only 21 senators, not 23. The leader of the opposition may only advise the Governor General to appoint 8 persons as senators, not 10. And it follows that any appointment beyond the allowed 8 must be unconstitutional. His Excellency the Governor General relied on the leader of the opposition's assertions that the senators Williams and Tufton had resigned. The court has declared that the procurement of the pre-signed undated letters of resignation is inconsistent with the Constitution, unlawful, and null and void. Having regard to Jamaica's constitutional arrangement, His Excellency would be under no duty to investigate and contradict the leader of the opposition. Indeed, if he did so, it might have seemed awkward, if not inappropriate, to the leader of the opposition and to any student of constitutional law. The full court, consisting of 3 Supreme Justices, gave a declaratory judgment in this matter, as was prayed for by the claimant. There has been some argument in the public space by some who would seek to diminish the significance and solemnity of this form of a remedy. A declaratory judgment is a binding adjudication that establishes the right of and other legal relations of parties without providing for or ordering enforcement. Sorry.
Let the AG finish.
A declaratory judgment is a binding adjudication that establishes rights of and other legal relations of parties without providing for or ordering enforcement. Particularly when the declarations relate to constitutional matters or concern constitutional officers or institutions, it is expected that they will be complied with. In this case, the court did not go as far as to declare that Senator Williams and Senator Tufton are still holders of their seat in the Senate, but the following inferences may be made from the judgment. If the pre-signed and undated letters of resignation and letters of authorization are null and void, then Senator Williams and Senator Tufton did not resign. In those circumstances, they remain members of the Senate, and no vacancy was created in the Senate. Section 45 of the Constitution provides as follows. 1. Subsection 1. Whenever the seat of any member of the Senate becomes vacant, the Governor General shall by instrument under the broad seal appoint to fill the vacancy of a person qualified in accordance with his consultation with the Constitution for the appointment of a senator. And it is not consultation, it is advice. Just by way of explanation, when the Governor General acts on advice, he's obliged to follow the advice. In circumstances where he consults with, there may be some discretion if he chooses. In making B, going back to the Constitution, in making such an appointment, the Governor General shall, in any case where the member whose seat has become vacant, 1. was appointed on the advice of the Prime Minister, act in accordance with the advice of the Prime Minister, and 2. where was appointed on the advice of the Leader of the Opposition, act in accordance with the advice of the Leader of the Opposition. Whenever the seat of any member of the House of Representatives becomes vacant, the vacancy shall be filled by election in the manner provided by or under any law for the time being in force in Jamaica. So Section 45 is predicated on there being a vacancy in the Senate. In the leading text on constitutional law in Jamaica, the role of the Governor General in making appointments to the Senate is described as a formal function of the Governor General. In fact, Dr. Barnett states, and I quote, "In all these cases, the Constitution casts him in the role of a rubber stamp, quote unquote, and he is accorded no personal discretion. The Governor General, therefore, had no option but to perform his duty, and acting on the advice of the Leader of the Opposition that there were 2 vacancies, appointed Mr. Reid and Dr. Clark as senators in November of 2013. The issue arises as to the powers that may be exercised by the President of the Senate if Mr. Reid and Dr. Clark attend the next sitting of the Senate. Can the President of the Senate make a determination that Mr. Reid and Dr. Clark are strangers and inter alia order their withdrawal from the Senate? The Standing Orders of the Senate of Jamaica, 1964, makes provision for persons to be considered members and others to be considered strangers. It is apparent from the use of the term that persons who have been appointed as senators are considered members. Standing Order 81, subsection 3, provides as follows. The President may, whenever he thinks fit, order the withdrawal of strangers from any part of the chamber, its precincts, and may order the doors of the chamber to be closed. The Standing Orders does not define the term stranger. Standing Order 85 provides that resort may be had to the usage and practice of the Commons, House of Parliament of Great Britain and Northern Ireland for matters not provided by the Standing Orders. A leading text on the usage and practice of the House of Commons explains as follows. Officers of the House and certain officials on duty are normally not regarded as strangers, but are, with few exceptions, excluded from secret sessions. Section 44, subsection 1 of the Constitution is instructive, as it provides 1. Any question whether A, any person has been validly elected or appointed as a member of either House, or B, any member of either House has vacated his seat therein or is required under the provisions of subsection 3 or subsection 4 of section 41 of this Constitution to cease to exercise any of his functions as a member, shall be determined by the Supreme Court or on appeal by the Court of Appeal, whose decision shall be final. In accordance with the provisions of any law for the time being in force in Jamaica, and subject to any such law in accordance with any direction given in that behalf by the Chief Justice. A similar provision is in the Parliament Membership Questions Act. Section 3 of that Act states that any question whether A, a person has been validly appointed as a member of the Senate, or B, a member of the House, or has vacated his seat therein, or is required under subsection 3 or 4, section 41 of the Constitution to cease to exercise any of his functions as such a member, shall be referred to and determined by the court in accordance with the provisions of this Act. And every reference shall be by petition presented to the court in relation to the Senate by the clerk by authority of a resolution of the Senate, in relation to the House of Representatives by the clerk by authority of a resolution of that House, and C, in relation to either House by the Attorney General or by any other person. The Supreme Court has given a declaratory judgment that Mr. Williams and by extension Dr. Tufton's resignations are null and void, and I am of the opinion that it has by inference ruled on the invalidity of the appointments of Mr. Reid and Dr. Clark. It is my opinion that the President of the Senate does not have the authority to make a determination regarding the validity of the appointments of either Mr. Reid or Dr. Clark as senators. This is a matter that falls within the remit of the court, and a very strong argument can be made that the appointments of Mr. Reed and Dr. Clark were not constitutionally or validly made, having regard to the declarations made by the Supreme Court in Williams versus Holness. We can draw further inferences from the ruling. If there was no vacancy in the Senate, new appointments could not have constitutionally been made, and any such appointments would have to be considered invalid. Since Mr. Reed and Dr. Clark may not have been validly appointed as members of the Senate, what is the impact, if any, on the participation of Mr. Reed and Dr. Clark in the Senate and on other committees of that House? Section 51(2) of the Constitution provides as follows: each House may act notwithstanding any vacancy in its membership, including any vacancy not filled within the House, when the House first meets, or after the appointed day, or after any dissolution of Parliament, to be present or to participate in the proceedings of the House shall not invalidate the proceedings. So the significant part of that is that the presence or participation of any person who is not entitled to be present or to participate in proceedings of the House shall not invalidate those proceedings. Pursuant to Section 51(2), if it is declared that Mr. Reed and Dr. Clark were not properly appointed as senators, the proceedings of the Senate will not be invalidated for the periods and sittings in which they participated. In conclusion, I am of the opinion that in the light of the court's declaration that Senator Williams and Senator Tufton letters of resignations were null and void, they did not resign, and therefore there were no vacancies in the Senate. It would follow that, having regard to the mandate of the Constitution, concerning the numbers of persons that may be appointed, the appointment of 2 additional senators would be unconstitutional. In these circumstances, either the affected party should agree, or the matter should be referred to the Supreme Court, pursuant to Section 44 of the Constitution of Jamaica.
Thank you, AG. You have given us quite a bit. But before I open the floor for questions, Hopeton, we spoke to you last week. I'm going to say it publicly, and the week before. When we have a guest who is speaking, please do not interrupt them. You have to be courteous to your colleague media reporters as well as to the guests. And we're going to ask you for the last time, just allow the person making the presentation to do so. And when we're through, if you need clarification or you have something to be answered, just do it then. But please do not interrupt. We open the floor for questions. Andre, one question, a follow-up, and then we go around the room.
Mr. Attorney General, sir, based on what you've said today, and based on the action of the opposition leader, in this Westminster system of government in which we operate, should the opposition leader resign from his post?
The question as to what the opposition leader should do in these circumstances, I think, is more appropriate for him to answer in consultation with his own party. It's not an area that I would venture into.
No, I'm talking about the system of government in which we operate, not from a party standpoint, but his constitutional role in all of this matter.
There are conventions, and very often that constitutional officers would resign in event of certain occurrences, I don't know of any situation that is exact to this one. When the leader of the opposition makes gives his advice to the Governor General, this is after he has taken certain a political decision and had political advice amongst his political advisors, and clearly it is a matter for them in those circumstances to decide what he should do, what's the appropriate thing.
You have a follow-up, Boundary? All right, we go to Doreen Luton.
Thank you very much. Attorney General, notwithstanding your view that the sittings in which both Dr. Clark and Mr. Reid participated would not be invalid by virtue of the Constitution and those aspects that you have cited, will the government be considering, just for security, a validation bill to validate the actions done by those senators, just for the security reason? And also, senators are paid a stipend. Did you give contribution to what happens in the case of Tufton and Williams, who would have lost income as a result of that, and those stipends, those monies paid over to Dr. Reid, Dr. Clark and Mr. Williams in that regard?
If one looks at the citizenship disqualification cases in the past, nobody was asked to refund any salaries, and MPs get salaries. In this instance, in the case of the Senate, they are not paid a salary. The Senate receives a stipend for attending Senate meetings. If they don't attend meetings, they're not given a stipend. I actually, at the first part of your question, I read I was actually quoting from the Constitution, so I do not think it's necessary to recommend any ratification or otherwise of the action. I think the legislation in particular that were passed are valid.
You have a follow-up?
Yes, please. Just venturing into new era with a follow-up, if that's okay with you.
Outside of this discussion?
No. I wanted to know, in terms of the advice, therefore, that you would give to the president tomorrow, tomorrow being Friday, if the four gentlemen in question turns up, what happens? What should he do?
I think it would be inappropriate for me to advise the president as to exactly what he should do. I can advise him what the law is, and clearly it would be a matter for the Senate itself to decide how to resolve it by a resolution. They could decide to go to court, they could decide to ask the Attorney General to take a lawsuit, or they could take whatever action they think is appropriate. Actually, the Senate is a very important institution in our whole constitutional arrangement, and really I know that the parties involved are responsible persons, and I know that they are persons who do have a good, strong sense of their civic duty, and I would anticipate that they will do the appropriate thing not to create any sort of undue embarrassment to this important institution.
Balfour. Come to you.
The Supreme Court and the Court of Appeal as another area to which some clarification could be sought. Didn't you? I think you referred to the Supreme Court and the Court of Appeal.
The Court of Appeal would only arise if after a decision was taken by the Supreme Court and it was appealed. The Court of Appeal's role would be appellate. In the instant case, you have a decision by the full court. It's not by a single judge. The full court is the court sitting with at least 3 judges, and it was a unanimous decision. almost to the letter by all three judges. It is a decision that carries a lot of weight.
But the substantial question I want to ask you, also, don't you think that this ruling and this decision that you have made today have raised some concerns as to how, like for example, the Prime Minister and the leader of the opposition will be able to control people who could become like loose cannons in the Senate under these kind of conditions?
The Senate is supposed to be a review chamber and
Yeah, but
body.
we can't judge what will happen in the future.
People who are like loose cannons. Wow.
Your terms are a little bit strong, but Minister is correct. The Senate is supposed to be a review chamber, and there really shouldn't be any sort of control placed on how senators conduct the business of the country by either the Prime Minister or the leader of the opposition.
Sure, I will give you a hope that it's a follow-up to that, so we'll allow it.
Yeah, because part of the argument that the opposition leader made in one of his statements is the fact that the reason there is a 2/3 to 1/3 majority in the upper house is so that the government cannot go ahead and change entrenched situations in the constitution, and so to have the opposition senators unified on a particular position is important, which is why the letter was used on these two gentlemen.
But that is not eventually what occurred, why the letters were handed in to the Governor General. That's not what eventually happened.
There was a little bit, it's one of the areas where the issues were not unanimous or between both the claimant and the defendant. But what the court's ruling was based on the submissions that whatever the reason for the letters, it was inappropriate. Because you'll recall that the language, which I think is very instructive, that was used was contrary to the Constitution, against public interest, unlawful, null and void. They're very strong terms. Any one of those terms by themselves would be strong enough, but to juxtapose the four of them.
In other words, the letters have been used in the character of they would still be unconstitutional.
If the letters are used for what?
For the CCJ vote.
It was said to be intended for the vote on the constitution.
CCJ.
I think it would be inappropriate, since the Senate is and the court did indicate that the Senate is a review body, and each senator should be free to contribute and make his decision. Which does not mean they can't listen to what their colleagues or anybody has to say on the subject before casting their vote. But the point is that if the leader of the opposition were allowed to select senators and to hold a letter over their heads as a sort of big stick for them to vote on a constitutional issue like that, it would be tantamount to giving the leader of the opposition the power of a veto of a bill, of a constitutional bill, which I don't think the Constitution allows for.
But they represent a political party. I mean, they are appointed by the leader of a political party, and the members of those parties expect that the leader will appoint people who will carry forward their views. I mean, not the views of other people.
And political parties have philosophies and a mandate when they are elected, and they're persons of the general philosophy, of the same political philosophy. But actually, this is something different from controlling how a senator will vote on a specific bill or on a specific matter. It's not that then you wouldn't need to appoint anybody. You just follow the party's policy on it, and having a vote would be really a waste of time. Whereas in the lower house, you have whips and the party line on fundamental issues, issues of policy. If the party's policy is in a particular direction, and if anyone wishes to vote against it, then they cross the floor and sit on the other side. But the Senate is supposed to review it to see that politics do not overwhelm the legislative agenda, and that there's some sort of independent and second thought on issues. And that's what the Senate is supposed to do.
Will force the leader of the opposition and the Prime Minister to think much longer and deliberate much stronger when they are appointing people to the Senate, that they ensure that these are people will be loyal to them and their party. You don't think that will happen?
I don't know what each individual person will do. I don't know that the Prime Minister is in any way involved in this. I don't think there are issues, because you will have heard, but be reasonable. You have heard 7 senators on the government side in the Senate who have taken a different position from the mainstream and call for review and rethinking of bills before they vote. So I don't know how we get there.
And I think the Prime Minister, why the Prime Minister should not even be pulled into this. The Prime Minister appointed 13 senators. None of us, we were not given letters to sign. So we have a different philosophy on... No, but I think leaders generally, when they think about who they're appointing, they think long and hard about the persons they are appointing. And as the AG said, each group comes with a philosophical position, and the Prime Minister would appoint, I can speak for her, would appoint persons who are responsible and who have a particular view. Certainly on our side in the Senate, we have had instances where bills have come forward and we have put them back, deferred them because we needed further discussions because persons did not agree. So, Hopeton.
Okay, thank you, Madam Chairperson. And your comments earlier were misunderstood, but I understand, and I am always for good order, and we are still good friends, don't worry about it. Mr. AJ, the Honorable Attorney General, in your considered opinion here, I'm indebted to you for it, but I just want to say here that on page 5 of 13 in your circulated document, you stated, and almost in the penultimate or the last paragraph, in this case, I know you can read, so I'm not going to read it. In this case, the court did not go as far as to declare Senator Williams and Tufton as still holders of their seats. But you earlier said in your prepared statement, considered statement, I'm sure, that null and void means it's of no effect, no validity. So in other words, there was no vacancy. Therefore, isn't it quite clear that you could have concluded, therefore, and instead of going back into, you have really kind of muddled the water in my mind, my little simple mind, when you went back to say that section 45 on page 7 of 13, when you said that in all these cases the Constitution will cast him in the role of a rubber stamp, and he is accorded no personal discretion. And the question is, the Governor General, you have kind of covered the Governor General in terms of the validity of his action, being a quote-unquote rubber stamp based on what Dr. Barnett has said. And therefore, you're saying that the President of the Court of the Senate has no power. No, the question is, if the President, if the President of the Senate has no power to remove these quote-unquote strangers, and they were null and void, the appointments were null and void in the first place, what does this create? Do we have to go back to court to get a declaration if whether or not Nigel Clark and thing are still valid members? It really muddles the water. Why couldn't you just come and say, listen, these guys are not valid because they were null and void, and therefore they cannot come back to the Senate?
I thought I said that. I'm sorry to to confuse you.
But
But
I
I indicated that I was of the opinion that in light of the court's declaration, Senator Williams and Senator Tufton did not resign, and therefore there were no vacancies. And I made it quite clear that, in my view, that is what the decision meant. When I pointed out the fact the court did not declare, I meant they did not expressly say so. But by inference, one can draw that inference from the position that they took.
One final thing, sir. Follow, please. So, in going forward, please, we kind of want to make sure the public gets a very clear picture, because there's been a lot of talk about this thing. What is the position going forward right now as it exists? Let's make it in very plain, looking at the camera and saying in very plain language. What is the position going forward, please?
What is the position? Well, it is. It is indeed a very important office. Well, firstly, this whole idea of pre-signed and undated letters of resignations are unlawful and they shouldn't happen. Secondly, I'm of the view that since there was not a vacancy in the Senate, any appointment of two other senators would take it beyond the limit of the numbers that the Constitution prescribes, and hence they are not appropriately appointed. As to who will take the steps to effectuate that, I indicated that perhaps having regard to the importance of the Senate and the dignity of the circumstances, perhaps the four affected persons may come to some understanding, and two may gracefully withdraw and allow the matter to go ahead. Failing that, then the court should give that formal decision. But then that is reinstituting more court action, more weight, and as to what happens to the Senate, but the important matters that come before it daily is another matter. So good sense should prevail is what I'm saying.
Mr. Tufton and Mr. Williams were to turn up at the Senate tomorrow. The marshal couldn't lock the door on him. Couldn't lock the door.
Rohan.
Let me help, because out of an abundance of caution, that's what I was outside. I had to step outside for a minute. Pardon my departure. But would the Senate President have the power to declare them strangers? And if so, is it that they will be barred physically from the entrances to Garden House?
If he did declare them strangers, and
does he have the power?
the President has the power to ask the Marshal to exclude anybody, even a member who is misbehaving and disrupting the session. So he does have the power. As to whether it's appropriate to use it at this particular in these circumstances, another matter. It's a matter for the President and the Senate itself to decide.
Just to follow up, I remember Arthur, he got a phone call. And that's what he did. He decided not to go to the Senate because he got a phone call, and then he turned back. Arthur Williams at the time, when he was told that he was no longer a senator. So it really makes us wonder, just to follow up again, what will in fact be the case if the men will be restrained, and a worst case scenario here?
There are too many ifs. First, well, I don't know that they are going to show up tomorrow. As I indicated, that the four gentlemen involved are indeed responsible persons. I'm not sure that they would turn up, but if they did, I'm not sure how the President would treat it.
Did anyone?
So, I don't want to really speculate as to what might happen.
The Governor General, we heard you clearly, but did anyone consult with the GG on this before he accepted the resignation letters? Did he express any concerns to your knowledge, sir? If
I
you are
don't
aware?
know what transpired and certainly when the leader of the opposition is advising His Excellency. I am very unlikely to be privy to those discussions. But let me make it clear again. it is not the Governor General. The Governor General has a specific role in our Constitution. If the leader of the opposition, who he knows is the leader of the opposition, comes and makes certain assertion, I don't expect that the Governor General would conduct a mini hearing and a mini trial to say, I don't believe it, let me check it out. I don't think it would be appropriate, and I'd be surprised if he did. Very often you will see things happen and you may say to yourself, why is this happening? But that is not your remit, so you act.
Darren Luton?
Just seeking indulgence, AG. Isn't there a provision in the Constitution for the President of the Senate to name persons who are not senators to sit among senators? And if I haven't read that provision correctly, how would that work in a situation like this if the two strangers, as provided in the standing orders, are there? Can they not sit amongst senators and participate?
If he declared them strangers, and that's a first if, he then could exclude the stranger from a particular sitting, assuming it's not in committee. In committee, persons who are not senators may sometimes sit to sort of give testimony to assist the Senate in arriving at this decision. But if he declared them strangers, and if he thinks in the circumstances after consultation with the Senate that it would be inappropriate for them to be there, I'm sure he's the person who is in charge of the Senate. He's the person who is in charge of the meeting of the Senate. And so in those circumstances, he would have that power. But that doesn't necessarily mean that I anticipate or expect that will happen.
1 second, Balfour, allow Jevonson. He was ahead of you, and then we
sorry, AG. Can you just tell me, sir, what you think is the weight of your opinion in this matter? Why you came forward with it? That's one. And can you also tell me who else contributed to this opinion?
What is the weight of the opinion? Well, the Constitution places me as the principal legal advisor to the government, and so it doesn't say that anybody must accept the advice, but they usually do. As to who contributed, I don't know what that means, because we do research using legal.
Anybody from outside participated, like a
No.
Dr. Barnett or?
No.
Balfour, and after Balfour we take one more question.
I just wanted to
Use the mic.
But just to tell you, Andrew, I do have a staff of competent and experienced lawyers, and we do practice like a chambers, which we are, in that when we write opinions, we bounce it off each other, and if you are unsure of something, you ask someone else. But we work as a team in the Attorney General's chambers.
Yes, I just wanted to make sure that I understand three things that you said. So, one is that the Senate is an independent body. They do not have to toe the party line. Two, that the leaders who appoint senators should have no authority over them while they sit in the Senate. And three, that all senators should be free to express their own opinions. Am I correct in this?
I don't know, and I'm not sure that I would agree with you as use a strong term to say it's an independent body. It is part of the Houses of Parliament. But the senators, and in fact I was trying to find the area in the judgment where the court actually made reference to the fact that senators should be, the Senate is a review body and should be allowed to make their independent decisions on matters. What was the third requirement?
I'm saying that all senators should be free to express their personal opinions on issues that arise.
As indeed any representative government is. Another question is the circumstances and the location when those opinions may be expressed. I wouldn't say you can express your opinion. You can express your opinion, but there are very often consequences. In the lower house, you would have to, or in the Senate. But
people in the lower house, they are elected and they have the authority of the people elected. I'm talking about people who are just appointed to the Senate, people who are probably not even known to the members of the political party, which appointed them, and the decision is taken by the people, either the Prime Minister, the leader of the opposition, to appoint these people.
The Constitution of Jamaica points out the circumstances under which a senator may be removed. And disagreeing with anybody is not one of those circumstances. I'm sure if they are members of the party, a party may even consider amongst themselves what steps to take, but certainly they cannot be sanctioned for taking an independent position.
So what about the one that whether they should have over so that they appoint to the Senate?
Follow the Constitution.
I think the Constitution is clear on the point, and
I think we have to ask the framers of the Constitution that question. We have to ask the framers of the Constitution. But we have to obey the provisions of the Constitution. And well, we couldn't answer that question here. That would. We're pretending. You're getting quite emotional, Balfour.
That's why I mentioned what I'm saying. You're creating a situation in which these people will have to be very careful about who they appoint to the Senate in the future.
We're taking one last question. We're taking that question from Andre, and we wrap up.
No, he says no. He says no.
No? All right. Ladies and gentlemen of the media, we thank you very much for coming, and we know that this is not our usual time. We wish you a good afternoon.